Rockich, and are both sides ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
And you each will get 15 minutes of time to argue your cases, and the appellant may reserve up to 5 minutes. And when you're ready to proceed, we're ready to hear the arguments. Thank you.
Thank you, Your Honor.
I want to make sure, because I was just telling the other judges in our new courtroom, I get confused easily. I'm going to have to learn it all. But evidently, the camera is set up in a different location, so you are being recorded. And so I just ask that you stay behind the podium and keep your voice up. Thank you.
Thank you. May it please the court, Mary Randazzo on behalf of the appellant. I'd like to reserve 5 minutes for rebuttal, please.
Sure.
Thank you, Your Honor. I did not ask for oral arguments in this matter. I feel that my brief has detailed all of our position relative to the issue that's before the court. But I do raise for the court's observation that the record of this particular case is long. This is litigation that began with the 2005 dissolution, and then the litigation that led to the sanctions began in 2012. That was a judgment entry finally ruling on the underlying change in custody and awarding sanctions on January 4th, 2017, and that was appealed. This court affirmed the matter of the sanctions a year later, on January 10th, 2018. In that appeal, the appellee in this case did not raise the issue of when the payments would start or the amount of the sanctions. The only thing that was raised was that sanctions were awarded at all. This court affirmed the judgment entry from January 4th, 2017. And at that point, that entry was final. 14 days later, after this court affirmed that judgment entry, the appellee filed a captioned motion to set an effective date for monthly payment obligation. I direct the court to the docketing transcript number 561 for that motion, within which the plaintiff at that point, the appellee, raised only 2 issues. One is that she does not have the funds available to her, and 2, that she asked the court to set a new date in the interest of fairness and equity. Those were her requests. That is the extent of the motion that was filed. A proposed entry, checkbox style, was provided to the court by the plaintiff appellee, and the court simply granted.
Counsel, what do you think the remedy should have been? If, it was on appeal, so obviously the date that she was supposed to start paying had long since passed, and she did obtain a stay. Whether you agree with it or not, she did obtain a stay. So what do you think the remedy should have been?
I believe that she should have been putting aside the monthly payment into an account, just as though she had been ordered a supersedeas bond, which was denied both by the trial court and this appellate court. And this, unfortunately, is the unintended consequence of the denial of the supersedeas bond, is that just as has happened in this case, the red letter day came and she didn't have the funds sitting that should have been available to the defendant. To make note, the defendant had to take out a loan of his own to finance the litigation. He had to continue to pay interest on that loan as well as his payments. If we were to affirm the lower court's decision in this case, we'd have a flood of litigation because this is a no-interest loan being provided to whomever appeals for the period of time that it takes for the process to go through the appellate court. She was aware of what the terms were. The language is completely clear and unambiguous. The language states that the first payment is due on the first of the month following the date of, quote, this judgment entry, end quote. She was aware of the consequences of her request of stay. In addition, she's raised several issues on appeal in her appellee's brief, which were never preserved at the lower court level. She raises impossibility as one reason why she sought that motion. Motion doesn't state anything about impossibility of payment, impossibility of following the terms of that payment. It simply says, I don't have the funds available. can't do it. She raises the issue of clarification, that it wasn't a motion to modify, which would be impermissible and a nullity pursuant to Allstate Insurance versus WIDA coming out of this court. The context of post-judgment matter, actions that purport to reconsider or alter a final judgment are a nullity. She now tries to bend and state that no, I was simply asking for clarification, yet her motion is devoid of any language which states that that the judgment entry was ambiguous, that she needed clarification, because the language is clear and unambiguous, and it doesn't comport with her new theories. The fact that she has in her responsive brief tried to bring those before the court is impermissible. They were not considered by the trial court. The record is bereft of any of these new arguments and should not be considered by this particular court. Every day that went by after the date of the original entry damages my client. It imposes upon him a no-interest loan in favor of the plaintiff while he's incurring interest costs for himself. We request that the court reverse the trial court's judgment entry and uphold Allstate's finding that final judgments are final, and an attempt to alter them is a nullity in fact.
Let me ask you a question about the
Yes.
supersedeas bond. I know you oppose that the court didn't grant a supersedeas bond or require a supersedeas bond. You said you then requested that we impose it and we refused. Did you have an obligation to appeal that?
I believe that there is a possibility of appealing appealing the supersedeas bond. The arguments related to the supersedeas bond are provided to provide the necessary information to this court of what the unintended consequences are of the denial of a supersedeas bond. I believe that a supersedeas bond is a requirement. It is not a permissive. The appellant does not need to request a stay, but if the appellant in that case requests a stay, it is mandatory that a supersedeas bond is provided. The permissive language of may is related to the appellant asking for the stay. It's not related to the appellant asking for a stay and a supersedeas bond. And so in this case, that argument is provided so that the background is clear to the court, that the unintended consequences of the trial court and the appellate court's denial of the supersedeas bond has come to fruition in this case, which is she no longer has or is indicating she doesn't have that money available.
So as a requirement and two courts refusing to do it, why didn't you have the requirement to appeal something that basically affected substantial right, as you're saying?
At the time that the appellate court here denied that and we were entering into the appeal of the underlying matter, the finances weren't available for my client for me to proceed on to the Supreme Court on that particular issue, and it would have caused further delay in exactly the issue that's before the court, which is he is incurring costs that he took a loan for the litigation, and it would have delayed further him being able to start to receive those funds that he was awarded because of her frivolous conduct, specifically the delay. We are now in 6 years of litigation, and she has delayed and delayed and delayed, and there is no other just reason for her to have filed that motion but to delay further.
Counsel, I guess what I'm asking, and I didn't do it well, I know you filed the motion in opposition. I don't know if you did, but I'm saying, I'm imputing everything to your client. Filed the motion in opposition and said, requested our court to order it. But could you not have, the moment the trial court denied or granted the stay, but denied the requirement of a supersedeas bond, couldn't you appeal that to our court, is what I'm getting at?
I believe that the appellate court rules are clear that once you seek it and it's denied at the trial court, you may then seek it in this court, and that I did. I filed a motion in this court requesting that the stay be terminated, or in the alternative that the supersedeas bond be set. This court denied, the appellate court denied that request, and at that point I could have appealed that denial to the Supreme Court, but that would have further delayed the action. Thank you, Your Honor.
Yeah, no, you're fine, you can keep talking, you have time, but I just wanted to say I understand what you're saying.
If I've answered your question, then I would leave it open. Don't want to go over anything that you already understand.
Well, you have a little over 5 minutes remaining.
If there are no further questions,
Any questions?
Yeah.
All right,
Thank you.
You have 5 minutes remaining.
thank you.
May it please the court. Good morning, your honors. Good morning, counsel. My name is Jack Hindenburg, and I represent the appellee, Heather Condon. This instant appeal arises after extensive post-degree custody litigation ensued relative to whom should serve as the residential parent. On May 18, 2016, a trial court magistrate, in addition to parenting and child support matters, found father's motion for frivolous conduct and sanctions to be well taken in order that mother pay father's legal fees and costs in the amount of $20,840. After the judge upheld all matters of the magistrate's decision, mother appealed this judgment in appellate case number 28479. On January 24, 2017, soon after filing her notice of appeal, mother filed a notice to stay in the trial court so that mother's payment of the attorney fees and costs only could be stayed pending mother's appeal. The motion to stay was unopposed and granted, and the court ordered that the judgment entry as it pertains to attorney fees and costs as sanctions against the plaintiff be stayed pending the outcome of mother's appeal. After the stay had been granted, father moved for the stay to be terminated, or in the alternative, for mother be required to post a supersedious bond, which was denied. On January 10, 2018, mother's appeal in case number 28479 was affirmed in part, reversed in part, and remanded. The assignment of error pertaining to the attorney fees and costs to father was overruled. Since mother was originally to begin making monthly installments of the attorney fees and costs on February 5, 2017, but the paying of attorney fees and costs were stayed by the trial court during the pendency of the appeal, mother filed a motion to set an effective date for monthly payment obligation from plaintiff to defendant based on date of the appeals court decision on January 25, 2018.
Counsel, if a stay is granted, and for whatever reason a supersedious bond is not granted, does that relieve a client from payment after the case is over if they've lost?
So it does not. Our argument would be that as to those dates did not have to be followed because it was stayed while it was appealed. I would have to go to the Ohio Civil Rule. Let me find it real quick.
That's fine.
Ohio Civil Rule 54A. Ohio Civil Rule 54A states that judgment as used in these rules include a decree and any order from which an appeal lies as provided in section 2505.02 of the revised code. So that would be a separate order from the appeals court pertaining to that original judgment in this case. So it's not that that judgment will be out the window, just as to that dates would be altered based upon the judgment from the Court of Appeals, which would go back and change the time in which payment was to be made, just because that appeal judgment cannot be ignored.
I'm just trying to think how you alleviate, if you don't set a bond, how you alleviate the alleged prejudice that she's talking about.
We never wanted to set aside paying the money that was due and owing pursuant to the sanctions. What we wanted to do was, after the stay was lifted and it was remanded back to the trial court, start making the monthly payments as originally ordered by the judge. And when we filed our motion with the trial court is just in order to get clarification from that trial court as to when payments would have to start being made, given that this matter was stayed during the appeal.
So could the court have said, payment started when I told you a year and a half ago, and you need to have in 30 days or whatever, $12,000, $15,000, whatever it was.
Sorry, Aaron, could the trial court have said that, or
Sure.
the appellate court?
Or either one, as far as that goes.
I think it's possible that they could have said that. I think that would be somebody ignoring Ohio Rule 54A, in that it's not taking into consideration the judgment from the Court of Appeals. But I think it's probably within the judge's discretion to make that ruling. Rather, the judge in this instance, based upon his discretion, decided that the monthly payments were to start on the date of the judgment which came from the Court of Appeals.
Did he order, I can't remember, I don't think he did order any further interest or anything because of the delay?
Your Honor, I don't recall there being further interest ordered. I could be wrong, but I don't recall there being further interest ordered.
I'm sorry. We're going to get get you off track too much.
That's all right. Okay. On February 26, 2018, Father appealed said order, raising two assignments of error that all resolve around the court clarifying its judgment when it set the effective date for monthly payment obligations, as well as an issue with the lack of a supersedious bond. Appellant's first assignment of error, appellant's first assignment of error, he claims that the decision of the trial court to modify a previous judgment was prejudicial, an abuse of discretion, and an error of law. The issues before the court pertaining to this assignment of error is whether it is appropriate for this court to consider a typographical error in the lower court's judgment and whether it is proper for a trial court to clarify the terms of a domestic relations judgment pertaining to the attorney's fees. As for the first issue pertaining to typographical error, Father incorrectly assumes that a typographical error necessitated this appeal. A simple nunc-pro-tunc order is appropriate to correct a clerical order or mistake pertaining to an already issued judgment or order. A clerical error or mistake refers to a mistake, an omission, mechanical in nature, apparent on the record, which does not involve a legal decision or judgment. This is pursuant to State Ex Rel Cruzado versus Zaleski in the Ohio Supreme Court case. Although courts possess inherent authority to correct clerical errors in judgment entries so that the record speaks the truth, nunc-pro-tunc entries are limited to proper use to reflecting that the court actually decided, not what the court might or should have decided. That is from the same case law that I stated. So in this instance, as it pertains to the typographical error where the defendant and the plaintiff was switched, that could have been resolved with the nunc-pro-tunc rather than filing an appeal in this matter.
Well, either side could have filed none.
Right, either side could have filed the nunc-pro-tunc.
Who actually prepared the order?
I'm sorry, Aaron?
Who prepared the order?
That was prepared by plaintiff's counsel. It was prepared by plaintiff's counsel, reviewed by the judge, and then it was affirmed by the judge. The lower court's judgment in full stated the defendant's effective date of a monthly $1,250 payment obligations shall begin January 10th, 2018, and continue for 20 months thereafter until their $25,000 payment obligation is paid in full. Again, this was supposed to state mother's effective dates. This is a typographical mistake and harmless error, and was clearly not the intended language of the entry. And further, because mother is not at all seeking payment from father pursuant to this clerical mistake, father has no basis for this argument. As to the second issue pertaining to the trial court's clarification of the terms of a domestic relations judgment pertaining to attorney's fees, father incorrectly argues that the judgment pertaining to attorney's fees in a domestic relations case cannot be clarified by the trial court as to an appropriate effective date to begin making payments after a lengthy appeals process. However, it is well settled law in Ohio that a court has inherent authority to clarify a judgment entry sua sponte where confusion exists as to its meaning. This is pursuant to Long versus Long. And in this case, it is clear that a modification of the order has not occurred and relief from judgment has not been granted, as father suggests. Rather, the trial court merely clarified when payment of an attorney's fees was to begin, a matter within judicial discretion. The 2017 judgment states as following: mother owes to father the sum of $25,000 for which judgment shall render, which represents attorney's fees and extraordinary costs due to mother's violation of civil rules, frivolous conduct, contempt, and discovery violations. Mother shall make payment directly to father in 20 equal monthly installments of $1,250, with the first payment due on the first day of the month immediately following the date of the timestamp of the judge's judgment entry. As you heard, there was no acceleration clause in the entry, and nowhere in the 2017 appeal decision does it state that payment of the attorney fees become due immediately upon the conclusion of the appeal, as father desires.
Why would we have to say that if the judgment entry from the trial court that we affirm said that?
I feel like it could have been said in order just to clarify the judgment that was running in the trial,
But
court.
I understand that point, but I'm just wondering, how is it required to be said?
It was not required to be said. It just maybe would have given clarity to the trial court's decision, which we then tried to, straighten out after it was remanded back to the trial court.
And the appellant is saying, well, that's an issue you could have raised on appeal too, if she was lacking funds, that was not a reasonable payment schedule.
We would still believe that the money would not be due, or we would not be able to be required to start making those monthly payments until the matter had been remanded back to the trial court and was no longer stayed.
Okay.
the trial court, upon motion by mother, alerted the trial court to the impossibility of following the effective date as originally contained in the magistrate's decision, the trial court clarified its prior order sua sponte as it pertained to when mother was to begin making payment of the attorney's fees owed, and the clarification did not change any material aspect of the judgment, just when the monthly payments were to be made. The amount of the judgment or the payment terms did not change, only when the payments were to be made, which was necessitated by the stay that had been in place during the 2017 appeal. It was impossible for mother to abide by the terms of the judgment and retroactively make payments. Since the trial court was simply clarifying its order, there was no need to comply with the modification procedure.
Counsel, how long was this on appeal?
The
Year and a half or
2017
so?
appeal, I don't recall the exact amount of time. It might have been around a year, 10 months, or a year, something like that. I don't recall.
But in essence, then the trial court did change its judgment entry by changing the payment terms from 20 months from the date of the original judgment entry to 32 months.
That did change, Your Honor. When the monthly payments were to be made, did change, but the amount of the judgment didn't change, and the amount that father would receive did not change. The correct standard for review in this matter is abuse of discretion, not de novo review, not de novo standard of review, as father contends, as the effective date of payment of obligation is not an application of a rule or statute, but was discretionary in terms of judicial administration. Furthermore, father suggests that mother is collaterally attacking the judgment, which is misguided and incorrect. At no point in time did mother file a motion for relief, a motion for reconsideration, or any filing of that sort. Additionally, father's argument that the trial court erred in setting an effective date for mother's payment obligation blatantly ignores Ohio Civil Rule 54A. I spoke of this briefly prior. It states that a judgment as used in these rules includes a decree and any order from which an appeal lies as provided in section 2505.02 of the revised code. Because a judgment specifically contains a determination by an appellate court under this rule, the appeals court decision of January 10th, 2018 becomes the new judgment from which mother has been ordered to pay attorney's fees and litigation costs to father. Therefore, the date mother's payment obligation is arguably the first of the months following this date, a fact utterly disregarded by the father. As to appellant's assignment of error number 2, he claims that in a domestic relations proceeding, a supersedious bond is required as a condition of a stay of a monetary judgment pending appeal. The issue pertaining to this assignment of error is whether the trial court was in error in granting mother's motion to stay without ordering a supersedious bond. Father incorrectly claims that mother was required to post a bond for the trial court to grant her motion to stay pursuant to revised code 2505.09 and Civil Rule 62B. Revised code 2505.09 states in pertinent part, except as provided in section 2505.11 or 2505.12 or any section of the revised code or in applicable rules governing courts, an appeal does not operate as a stay of execution until a stay of execution has been obtained pursuant to rules of appellate procedure or in any other applicable matter. In this case, there is an applicable rule governing the court stating that posting of a bond was not required in this instance. Civil Rule 62B specifically states that when an appeal is taken, the appellant may obtain a stay of execution of a judgment or any proceeding to enforce a judgment by giving an adequate supersedious bond. The bond may be given at or after the time of filing the notice of appeal. The stay is effective when the supersedious bond is approved by the court. The rule clearly uses may rather than shall, indicating that a bond is not necessarily required and is an issue left to the discretion of the court.
But isn't that the rule just saying, even with the supersedious bond, the court doesn't have to grant it? The court has discretion to grant a stay, but it seems to me like the rule is saying, but if you're going to grant a stay, then you have to have a supersedious bond so everybody's protected.
The way I'm reading it, Your Honor, I believe it says, the second sentence says the bond may be given at or after the time of filing the notice of appeal.
Right, but isn't that just telling about the timing of the bond?
The way I was
talking about the timing of this.
The way I interpreted that was, may be required that the actual posting of the money bond be issued, but not within the discretion of the court for there to be a monetary amount, a monetary bond given. Furthermore, father is precluded from raising this issue now as he failed to raise it within the time frame required by applicable law and rule. Upon mother's first appeal, mother requested a stay as it pertains to the payment of attorney fees and costs assessed against mother.
Counsel, you have to wrap up. You're out of time. I'm sorry.
That's okay.
All right. Thank you very much.
Thank you. Thank you, Your Honors.
Thank you. You have 5 minutes for me.
Thank you. In Appleby's recitation of his brief, he is repeating the language that the original judgment entry lacked clarification, and therefore the judge is simply clarifying. He also misread the actual judgment entry. It does not say the judgment entry or a judgment entry. It says this judgment entry. It specifically states, with the first payment due the first day of the month immediately following the date of the timestamp of this judgment entry. That language is clear and unambiguous and did not need to be clarified. Further, Judge Carr is absolutely correct that the 12 months was extended to 32 months by the judge making this change. And further, it is a material change. That cost my client $15,000 in the interest that was thereon for the year that the appeal proceeded. So he continued to pay interest to his loan while this was accruing as a no-interest loan to Applee.
Counsel, just for clarification, when we ask questions, we're not necessarily espousing rules of law. We're just asking questions and using hypotheticals. Or
Thank
does this
you.
mean that? That's fine, just for clarification.
Thank you, I appreciate
Since
it.
we're getting videoed, I want to make sure the public understands what that means.
Thank you, Your Honor. Further, the 12 months is significant. The 12 months is significant because if this were a qualified domestic relations order case that was coming before the court, and that entry stated that it was to the date of the entry, from the date of the marriage to the date of the judgment entry, then we'd have everybody who doesn't like the qualified domestic relations order language appealing. Why? Because I've just gained 12 more months of time that I can now divide the period of the employee's service. Or somebody who has been serving time for those 12 months. Those 12 months apparently don't matter anymore, so you've just been sitting in jail while your sentence has been reviewed because there's going to be a new judgment entry date, and now what do those 12 months mean? So the 12 months is very significant. Civil matters from a monetary standpoint, criminal matters from a sentencing standpoint. As originally filed by the judge, it was very clear that the intention was that payments began at the first day after the timestamp of that judgment entry. Of significant note, when the appellee objected to the original magistrate's order that was confirmed by the judgment entry in May, when he overruled all of the objections, he increased the attorney's fees and sanctions because of the further delay of the objections. The original order was $20,000. He increased it to $25,000 in the final judgment entry, overruling the objections of the appellee in this case. Clarification assumes that something was unclear. It was not unclear. Further, it should be noted that Civil Rule 54A that's being cited is a definition. It is defining the different types of entries which might represent a judgment entry. Nowhere and in no subsequent case law has that been interpreted to state that when the appellate court puts out its entry, it will now supersede the date of the previous entry of the trial court. In fact, the case law supports that the appellate court's entry, when affirming a judgment entry, reverts back to the judgment entry. It does not create a 12-month buffer, which would open up a flood of litigation in this court. Again, appellant requests that this court reverse as a nullity the judgment entry of the lower court. Thank you.
Thank you. Thank you both for your presentations to the court. The court will take the matter under advisement, and a written opinion will be sent to you. electronically on our website, and the Supreme Court posts them as well. So thank you so much, and the court will be adjourned for just a few minutes.